All right. Good afternoon, everybody, and happy Friday. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for engaging allied legal professionals to enhance services to clients, current and emerging practices from the field. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of this recording in an email from Zoom within 24 hours. If you don't see that email, I'm going to drop my email in the chat just in case. Feel free to reach out to me if there's anything that you need. The training was approved by the Florida Bar for one general CLE credit. I'll announce the CLE code towards the end of the session. I will also drop it into the chat, and it will also be included in the email that will go out from Zoom within 24 hours. Closed captions are enabled for anybody who needs them. If you are having any issues with accessibility or the captions, you can reach out to me directly. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I will also drop a link in the chat. I highly encourage you to take a look at their website. They have a lot of great subject matter areas and a lot of operating committees. I get to join and meet a lot of great people and advocates across Florida, so I highly encourage you to take a look at the PILS section. And final piece of housekeeping announcements, questions and answers. You will notice that we have the Q&A feature. If you have any questions for our speakers today, feel free to drop them into the Q&A. In the Q&A, if you want to drop an anonymous question, you actually have the ability to mark it as anonymous. And if the chat is also enabled, but ideally try to use the Q&A if possible. And our speakers will address any questions that you post towards the end of the presentation as time permits. So without further ado, it is my pleasure to introduce our speakers today from the National Legal Aid and Defender Organization, also known as NLADA. And we have Anne and David here today. So I'm going to pass it on to them so they can talk a little bit about NLADA and introduce themselves. David, the floor is yours.
Thank you so much, and thanks to everyone for having us today. We're really pleased to be here with you to talk about what we think is an interesting and important topic. So my name's David Miller. I'm NLADA's Policy Director. If you are not familiar with our organization, we are a national membership association for providers of civil legal aid, public defense, and the clients that those organizations represent. We provide training, technical assistance, and federal advocacy on behalf of our members. And this is one of those trainings, I think. So I'm going to pass to Anne, who's going to get us started.
Thanks so much, David. And thank you all again for joining us for this conversation. Just by way of introductions, my name, as you can see on the screen, is Anne Sweeney. I use she, her pronouns. I joined NLADA earlier this year as a member of the Civil Legal Services team. Prior to joining NLADA, I was with the Legal Aid Society of Cleveland for 20 years. I wore a number of different hats over the course of those years. I also have a social work degree in addition to my law degree. And one of the projects I worked on in Cleveland was incorporating client support services into their service delivery model. And we'll get a little bit into that later in our conversation today. But this is, I think, a really important topic, as David said, and increasingly relevant across the country, as we will share with you as we go through our presentation. So without further ado, our plan today is to welcome and introduce ourselves, talk a little bit about sort of the groundwork, the history of other professionals who engage in legal services delivery in a variety of ways, introduce the debate currently around this topic in the field, and share some examples with you of current practices, as well as sort of new and emerging models that rely on expanded legal aid practitioners to deliver service. We definitely anticipate having time for questions at the end. So as Jorge said, please do drop those in the chat as you think of them. And we look forward to having a conversation with you. So I want to start though by highlighting one of the real dilemmas that we struggle with, and that I think is somewhat universal right now in this space, which is, what are we really talking about? So we're using the language expanded legal practitioners at Legal Aid, right, at NLADA, to describe what is really quite a broad set of models and programs that all engage the expertise of other providers, advocates, professionals in a variety of ways to help deliver legal services. So it's easy to fall into the catch-all of maybe just referring to this group as non-attorneys or non-lawyers who are delivering legal services, and we're striving to move away from using that language. Importantly, I think it's a negative, right? It's basically calling out to folks what they're not getting rather than affirming what they are getting in terms of a new service or service delivery option. It also has the risk of really sort of diminishing the value of those practitioners and what services they're providing. So as much as possible, we're trying to avoid that term. And like I said, we've started using the term expanded legal practitioner or legal practitioner, but it is not universal. You'll hear a lot of different language. So you might have heard of allied professional, you might hear paraprofessional. Some of the more specific terms that are used for programs are community justice worker or legal technician. These vary across jurisdiction and based on what types of models different folks are trying to create. In any of these, depending on how they're built and how they're defined, you could have community advocates, social workers, paralegals, others who are involved in this space doing this job, right? There's no like uniform definition currently. And once David starts sharing some of the emerging models, this will become abundantly clear to you why language ends up being so different and also so important. So with that being said, I will continue forward to really the heart of the question, like, is this even allowed, or can we practice law with legal practitioners? And in true lawyerly fashion, it depends, right? So what is permissible in one state is not necessarily permissible in another. There is a lot of variation across jurisdictions about how legal practitioners can be incorporated into the delivery of legal services. So generally speaking, it depends on at least these three broad categories. I'm not going to pretend these are the only things to be thinking about. There's certainly important details in every jurisdiction. But at the outset, in terms of sort of the 10,000-foot view of like, what could legal practitioners do? These are three things to be like top of mind that we would urge folks to be thinking about. What are the state rules? What specifically do the unauthorized practice of law statutes say in your jurisdiction? What are the rules of professional conduct and which ones are relevant in a particular jurisdiction? And of course, are there any court rules that specifically might pertain to the use of legal practitioners? So know the rules, right? This sounds obvious, but certainly an area where there is nuance and there are important variations, and figuring out all of what a state has done in this space can be challenging because so much is changing and so much is new. The other big important question to answer is, what services are we really talking about having legal practitioners provide? And depending on the nature of the services provided, the rules will be different, right? So whether legal practitioners are providing information, whether they're helping folks fill out forms, providing advice, actual representation, is it in administrative matters, is it in litigation? All of these are really crucial questions to understand in order to know what is allowed and what is not allowed in a given jurisdiction. And then the third important question is, what attorney supervision is provided? So again, as David will talk about in some of the examples, there's a wide range. There's models out there that have actually don't require attorney supervision, but certainly much more commonly and under the traditional rules, attorney supervision is always a part of the practice and part of the model. And so just being really clear about how that's happening, what's required, and ensuring that those requirements are met would be essential as far as determining what is permissible in a particular jurisdiction. I also just want to call your attention to the ABA standards on the provision of legal services. I don't specifically have a slide on this, but I have a link at the end of our presentation, which you will get. But the ABA standards, specifically standard 4.9, calls on all of us in the legal aid community to consider using paraprofessionals, tribal advocates, lay advocates, law students, social workers, and other professionals when authorized by state, federal, tribal, and appropriate court rules, rules of professional conduct, and professional regulatory rules. So that is to say, know your rules, know what's permissible, but really there is a recommendation out, from the ABA that we all be thinking how to do this in ways that enhances our delivery of services to our clients. So what's the landscape in Florida? Let me just really clearly emphasize, I am not licensed to practice law in Florida, and I am not an expert on these rules in Florida. My goal in sharing this information on this slide is really to offer up to all of you some of what I think are the relevant rules and laws and opinions that I would be starting with if I were working in a program in Florida and thinking about the use of legal practitioners in service delivery. So these are really this is really an introductory presentation of some examples of places that I would start. In no way am I trying to offer you an authority or expert advice on this. But with that caveat, I do think it's important to note that Florida has some pretty specific on-point rules that are really relevant in this area. I thought, just as a off the bat starting point, that there is this 10-point or 2.1G that very clearly defines anybody who is not a member of the Florida Bar as a non-attorney, right? So you've got this very broad category of people who might meet other exceptions, but who are defined in the Florida rules as a non-attorney. Another, I thought, notable rule from Florida was the use of titles by non-lawyer assistants under 5.3, because it very explicitly requires that someone using the title of paralegal or legal assistant or other similar term offering services to the public must work under the direction or supervision of a lawyer or law firm. Not going to go through every single one of these on the slide, just offering up some of those highlights. There's a pretty broad definition of UPL, and that's in your Rule 5.5 with some case law sort of reinforcing that. At the same time, there has been some developments in Florida that carves out exceptions for the delivery of certain services. So form preparation, I thought, was an interesting area where there is both a rule and case law, making clear that anyone can complete a legal form with information provided by the person using the form. So again, just as an example of where there can be, pretty detailed application that could be utilized in thinking through service delivery options. And then I believe there's a somewhat newer rule that provides a similar specific call out for the completion of forms in family law by self-help centers. But as we continue and when we get to the Q&A, I certainly invite all of you as Florida practitioners to clarify or elaborate on any of these that you actually are utilizing or encountering in your practices and probably know more about. Okay, I am going to shift gears and talk about a couple of examples of how other professionals can be engaged in the delivery of legal services. And the examples I'm going to talk about are, I would say, relatively safe. These are not examples that really push the envelope very hard. They're, I think, ways of doing this in most jurisdictions, should programs want to try to replicate these types of models. That being said, they do certainly still require some careful planning and development in terms of making sure to operate within the boundaries of the rules. But as I referenced when I was introducing myself, I had worked in the Legal Aid Society of Cleveland, and one of the projects I helped develop and then manage was our client support services team. So that team is includes people who really, the focus is to work with clients in partnership with their attorneys to address barriers that clients face to effectively participating in their representation. The idea is if somebody is dealing with untreated mental illness, active substance abuse, lack of transportation, homelessness, etc., they are going to need to be focusing on those immediate needs and issues, and it may make it very difficult for them to fully participate, to communicate with their lawyer, to provide documents, to show up for meetings or hearings. And so our client support team in Cleveland was really skilled at supporting clients and helping them to navigate those issues in a way that allowed them to get the most effective representation possible. So on the slide is just an example, pretty typical type of situation that client support specialists in Cleveland would potentially get involved in, where a client facing an eviction reveals that also they're also struggling with domestic violence. The attorney has the option of inviting a client support specialist into the meeting and proceeding jointly to serve the client. In this, example, I describe how the attorney can focus on legal strategies, try to buy more time for the client, prevent the client from getting an eviction, which would interfere with future housing options. And meanwhile, the client support specialist can help create a safety plan with the client, can start pursuing alternative housing options. And really the three can work quite collaboratively together in this model, where, in a successful example, the extra time the attorney buys allows the opportunity for the client support specialist and the client to complete the application for a voucher, which allows the client to remove themselves from the unsafe, violent situation. And then also the attorney can get the eviction dismissed. So one example of how other professionals might be engaged in advancing services to clients is this type of a model. The other example I wanted to highlight is different in particular in that this is outside of the program, right? So the model in Cleveland was where the client support specialists are employees of the legal aid program. They work very closely in partnership with the attorneys and paralegals on cases for clients of the program. LegalLink is a nonprofit organization, mostly working in California, although they've done some other some pilot projects in other jurisdictions like Oklahoma and South Carolina. And they are really focused on expanding the legal ecosystem. So they're investing in training community partners on legal navigation assistance, how to identify legal issues, how to access legal protections, and then supporting people as they navigate the justice system. And so it's a little bit like a legal first aid. You might have heard of mental health first aid. Their model is more like a legal first aid. And they have a variety of trainings and programs that have, sort of a range of limited support and services all the way through much more in-depth, sort of full-time type programs to offer training one of the things we hear that is sort of in the pros list, when we hear pros and cons about sort of expanded legal practitioners, is that in some models and in some jurisdictions, using legal practitioners allows for service providers to really reflect their client communities' demographics and to incorporate people from communities in the delivery of services in a much more genuine way. And I saw on the website for LegalLink as just an example of this, that they report 83% of their justice workers identify as women and 85% identify as people of color. And among their clients, 89% identify as women and 92% identify as people of color. So it's just one example, but that is, as folks are weighing sort of some of the pros and cons, that is one of the things we've heard. As something a little less formal and a little less robust than like the LegalLink full separate organization model, I will also just say something I did a lot of when I was still at Cleveland Legal Aid was training community partners. So we had a whole series that we offered that was very much about making sure that the community health workers, that the librarians, that the faith leaders, like all the folks in the community who we knew were sort of go-to supports for our clients, had a foundational understanding of not just what we did and when to make a referral to legal aid, but some of the key issues that we were seeing and hearing about in our community and from our clients, so that they could be kind of the first line of intervention. And our thought about this and our approach was, you know, if there's any way to prevent it from becoming a legal case, we'd rather it get solved without ever having to call legal aid. And so thinking about sort of a prevention approach to legal services and doing trainings with folks in the community from that angle is, I think, just another example of how we can engage with other professionals in this work and to really serve our clients more comprehensively. So I am going to stop there and invite David to take it over. And like I said, we certainly anticipate getting to some Q&A. So that.
Thanks, Anne. So I am going to talk about a subset, I suppose you could call it, of legal practitioners. And the way I'm going to define this for you is this is individuals who, but for a rule change, would otherwise be engaged in the unauthorized practice of law. And so I recognize that looks different in different jurisdictions, but that's the most sort of useful definition I can give you at this stage. And I'll talk in more detail about specifically who I mean. So hopefully it'll become a little bit more clear. But the reason that we wanted to include this part of the conversation is because more and more states have been considering or have implemented programs that allow some individuals who are not lawyers to provide what they consider legal help in some limited circumstances. I think around about 20 states have seriously considered a program that sort of meets that definition, and at least 12 have implemented either a pilot or a permanent program. Again, I'm going to talk in much more detail about specifically what this looks like. I'll also talk a bit about sort of NLADA's work and position around this, and I'll give you some examples of things that we're seeing. But in general, the bullets on the screen are sort of the types of functions that are common to some of these programs. Sometimes legal advice, sometimes preparing and filing documents, reviewing documents, representing clients in certain settings. These are not uniform everywhere within these programs that we're talking about, but they're sort of common tasks and roles. that exist within one or more of them. So Anne, I don't know if I have control of this. Okay, thanks. So very briefly, Florida is one of the states that has considered doing something like this. You all will, I'm sure, know much more about the history and background of that process in Florida than I do. But it's not something that has moved particularly quickly. That doesn't mean that it won't. So NLADA currently as an organization, we are engaged in sort of a formal study and analysis of this issue, but we don't currently have a position for or against it. We do have two positions. One is that if a state is going to implement such a program, that they engage with, excuse me, the legal aids in their state and with the client communities in their state to make sure that it's actually going to be most likely to meet the needs of those communities. The other position is that we want our members to be educated so they can engage in those conversations. So that's really the purpose of our conversation today. And so how this has come up in 2021, the Florida Supreme Court requested that the Florida Bar review the rules governing the practice of law. Among the recommendations made by the bar that are relevant to this discussion were to create a regulatory sandbox where new or alternative legal services delivery models could be tested, and a limited assistance paralegal pilot program. The court declined to move forward with those proposals, and the bar came back the next year with a much more limited proposal, which, as I understand it, also was declined by the court. But as I said, I do think this is something that is likely to come up again because there is a growing national conversation around it. The first real formal example of this, I know there's a long history in tribal courts and in administrative proceedings, but the first sort of statewide program was established in 2012 in Washington State. That was the Limited License Legal Technician Program. And as you can sort of see from this map, which is quite small on my screen, actually, we have seen other states follow suit over the last 10 or 12 years. This is not all happening independently of each other. There are national organizations dedicated to coordinating this movement towards expanding the practice of law and regulatory reform. And there are different motivations for that. One, which of course we are very aligned with, is expanding access to justice. I think there's a recognition that we are not meeting the level of legal need that exists within low-income communities, and certainly want to explore any solutions that we can that may be viable to help narrow the justice gap. The other, which we are not concerned about, except to the extent that it intersects with the client community, is the efficiency of the legal marketplace, and are there opportunities to create new profit centers within the law. And again, I'll get into some more detail about how those two things intersect, but we don't. That's not a concern of NLADA's, and I don't expect the legal aid communities. But since some of the for-profit models are likely to target potential clients of legal aid, I think we do care that they're done correctly. So as I've been talking about this, I suspect that you all are like the national legal aid community in that you probably are having mixed reactions. And I think that's one of the things that we're really working on understanding. Again, we don't have a position because we know that There are different perspectives on this question. I think what unifies us as a community is that whether we are supportive or hesitant or opposed to expanding who is able to provide legal services, it's really driven by a concern for the welfare of clients. I think there's a more vocal opposition from the private bar, and maybe that is a little protectionistic. I just don't think that's where this community is. I think there are real concerns and they need to be worked through, but they are real concerns about the welfare of clients. So I'm going to just briefly define the different types of program that we've seen in different places, and there is some overlap within these categories, but this was the simplest way I was able to put it together for this conversation. So that's community justice workers, licensed paraprofessionals, sandboxes, and alternative business structures and technology. So briefly to define each, community justice workers are aimed at providing free legal help to low-income people. They might work or volunteer within a legal aid organization or another community-based organization. They are typically trained and supervised by that organization. They might not need an individual certification if they are under the formal supervision of a legal aid organization. A licensed paraprofessional may work under attorney supervision or independently. It depends on the state and sort of some of the specifics. They typically receive a certification to practice after demonstrating experience or education. They might be required to take an exam. As I said, they might be able to operate as independent practitioners, but they might also be employed by a legal aid organization or a for-profit law firm. They're not specifically focused on serving low-income people, but the nature of their pricing makes it likely, if they are a for-profit, that they will be intersecting with the legal aid client population as well. I've ordered my list wrong, so I'm going to go to alternative business structures next, because it's not really the focus of our conversation today, but it is part of this bigger national conversation. It really relates to how entities are structured, things like non-lawyer ownership of firms, for-profit companies that aren't law firms providing legal services as part of their work, technology platforms, for example, something that helps people fill in forms or uses AI to automate the certain legal processes and people's involvement in them. Something we are really concerned about and really is also a big focus of NLADA, but it's just not really part of this conversation today. So I'm just going to put it to the side for simplicity, but just for your awareness that that is a part of this conversation nationally. And then sandboxes really can be any of these things. They are essentially a structure within which regulatory requirements can be waived or suspended. So there might be a company or an individual that proposes a potential legal services delivery model that requires a regulatory change. And if the sandbox, which is maybe run by the court or the legislature, if they approve the pilot project, essentially, that company or individual will be able to implement their proposal, generally on a time-limited basis and with some type of oversight and data reporting. And so we've seen in sandboxes, CJWs, we've seen paraprofessional programs, we've seen alternative business structures. So that's really a space where there's a bit more freedom and flexibility. So some examples of each. A Alaska is sort of the exemplar of the community justice worker model. In 2019, the Alaska Legal Services Corporation, which is the statewide LSC grantee, obtained a waiver from the Bar Association, allowing people who are not admitted to the bar in Alaska to provide legal assistance in a limited capacity. So ALSC is responsible for training and recruiting those individuals. Once they're trained, they submit proof to the bar that that individual has received training. Those individuals are then covered under ALSC's malpractice insurance. And the program now has around 300 volunteer and paid non-attorneys. Sorry, I shouldn't use non-attorney. It's tricky to change language, but as Anne talked about, it is important. They engage in a lot of work. They're directly supervised by ALSC attorneys. Their main sort of focuses are will drafting, protective orders, and help with public benefits applications. So Minnesota has a paraprofessional program, but it is attorney supervised. It does require that a paraprofessional becomes certified. To get a certification, an individual needs to submit to the Minnesota courts both an attestation that they meet certain educational and experience requirements, as well as an agreement with an attorney that outlines their proposed scope of work and what areas they're going to practice in. And there are a number of areas and tasks that are delineated that they can do. And this does include providing legal advice and limited representation in some types of cases. Yes, as I said, they can work in, they are attorney supervised, so they can't work independently, but they can work inside legal aid or for-profit law firms. So Washington, as I mentioned, was the first to really do this. They have a paraprofessional program, but it is not attorney supervised. So to be able to practice, some are and some operate within firms in Washington, but there are a lot of independent practitioners known as LLTs, limited license legal technicians. And so to get that license, there's a lot that's required. Individuals have to complete 45 credit hours, and a credit hour is 450 minutes each, and 1,500 hours of substantive law related work experience that is supervised by a lawyer, in addition to passing an exam. So it's a very burdensome training process, but once that's completed, they are able to operate independently and unsupervised. So the status of that program actually is that it's being sunset in Washington. And the reason given was that the costs were not outweighed by the benefit, the administrative costs. Partly that I think is because of the burden of the training and the difficulty in getting participation from individuals because of those requirements. I don't think anybody thinks it was really a quality issue, but it'll be interesting to see where Washington goes from here. People who already are certified there will be able to continue to practice, but they're not admitting new LLTs. So lastly is Utah, and that's an example of the sandbox model. And so the way it works is that an entity, generally a company, will apply to the sandbox. It's operated by the Utah Supreme Court, and the court assigns them a risk level. And their risk is based on a number of factors, but it includes exactly what they're going to be working on. And excuse me again. The extent to which Utah licensed lawyers are involved in the project. If they're authorized to participate, the court collects data from them, monitors providers, and monitors their entities for consumer harm, and will randomly audit legal service case files. How stringent those oversight methods are depend on the risk level that they've been assigned by the court. But after a period of time, they actually can exit the sandbox and operate independently, assuming they satisfy the court's oversight for the period that they're in the sandbox. So this raises a lot of questions, and I'm not really here to give you answers to them, but to share what we think some of those questions are and some of the things that we've heard from our members and people interested in this issue. Again, I don't think anyone in our community is concerned about anything other than genuine quality access to justice. But in general, the sort of hesitations and concerns that we've heard about this relate to sort of one of basically three categories. That's sort of quality, equity, and accountability. And I will go through them sort of one by one. Quality, I think, is quite a straightforward question. At least the question is. The answer, of course, isn't. But really, it's, can people fundamentally who aren't licensed attorneys provide effective legal help? If they are people who have undergone specialized training to perform one or more specific tasks and only ever do those tasks, I think theoretically, we think probably there isn't a reason why that wouldn't be true. But we're not comfortable saying that until we really see some data that sort of backs it up. And unfortunately, we're just not in a place where there is enough. Sorry, I just saw the question pop up, but I think I will come back to it at the end because I'm nearly done with my part. There really isn't enough data at the moment. There's some, and there's more as more and more of these programs sort of get underway and get moving. There's sort of two main categories of data we're interested in. The first is really satisfaction. And an element of that is complaints against these individuals or programs or entities. And there is some good data already about that. And it's encouraging in that there have been minimal complaints generally that we've seen. Utah is very proud of the fact that of 24,000 people served by sandbox entities, there's been fewer than 10 complaints about them. But that's only half the story, because it takes a lot for someone to complain. And satisfaction is a much broader spectrum. And there really isn't good client satisfaction data yet. That's something that we've been advocating for states to really collect, because certainly that's really a key part of the question. But it also doesn't answer the whole question, because it's correlated, but not directly with a person's case outcome. And so we really want to know, are outcomes better, worse, the same if someone receives assistance from an attorney or someone who isn't an attorney but has received training in the particular service they're providing? Again, that's not something there's really good data on around. There's some historical data. There's a good meta-analysis of that data that I've linked to on the final slide of our presentation. That really showed there was a slight difference when the case was simple. That, of course, increased with complexity in terms of outcomes and success rate. But again, that's limiting because that was all really measuring programs and initiatives that existed before the sort of more formal iterations of those that we've seen over the last 10 years. There are a handful of studies that have compared legal work done by lawyers and people who are not lawyers, but are trained to do those same tasks, and found that there wasn't a difference. So really there isn't enough data for us to answer that question empirically, but there's enough there's enough really for people who are encouraged and concerned to have something to point to. I think it's still an open question, and it's one that we are really strongly urging people to try and answer. The second is equity. And I think fundamentally what we mean by this is, do we need to be worried that these programs create a lower tier or a second tier justice system for people who can't afford to pay for a lawyer? And partly that depends on the quality question. I mean, that's at the heart of this, but there are other elements too. And in some ways, there's a question of whether people who are not lawyers might be able to bring something different or extra to their service and their representation of clients. I mean, I'm sure you're all aware about the challenges that the legal profession has with diversity. A big part of that is the barrier to entry to the profession that is created by the requirement of having a law degree and the expense and time of that. And what happens when there is a lack of diversity is that you have more inconsistent levels of cultural competency, you have more attenuated connections to the communities that are being served. And so creating pathways to serving communities for people from those communities is actually something that we think is important, and we've heard from the client section of our organization is also really important to them, and it probably is the most important factor in whether they would trust someone to help them with a legal problem. So certainly the community justice worker model gets closest to making the most of that potential benefit. But that's not to say that some of the other models also couldn't. And lastly, the question about accountability. What do you do about someone who is providing inadequate help or actively causing harm to clients? I know that brings up a lot of recollections about particularly the immigration setting and people who have not been qualified to provide assistance, taking people's money and causing harm that cannot be rectified to their immigration status. For us, that depends entirely on the structure of a program. Certainly with an attorney supervised model, I think we are less concerned because there's that direct layer of supervision and oversight inherent in the model, but attorney supervision is limiting. And, you know, we think a little expansively about this. We can imagine the benefits of having someone, for example, at a nonprofit organization supporting survivors of domestic violence. We can imagine the benefit to having someone on their staff that can provide legal help to some of the users of that organization's services. So attorney supervision makes us feel better, and I think genuinely does provide that level of accountability, but can you find another way to achieve that accountability through whether it's oversight, licensure, some sort of formal process that doesn't require an attorney supervising the work? We don't have an answer to that. Again, these are just the questions that have come up repeatedly, and want our members and you all to start thinking about. And so I think that has brought me to the end of my portion. So Anne, I'm going to turn back to you.
Thank you so much, David. And we have sort of this option to move into talking about some scenarios, but before we get there, actually, I think it makes sense to talk about any questions you all have or any comments you want to share about your experiences in this space. So happy to pause here and hear from you all. If there's other questions, I know the one question we had, David, you did touch on. I don't know if you want to elaborate on anything more. If anybody else wants to chime in, please feel free.
First question
well-
was answered live by David. It was based on working independently. There is a new question that just popped up based on the previous slide. I don't know, and if you want to go back just to kind of put it in perspective. And the question is, could one of the contributing issues to be alluded to the potential threat that licensed attorneys feel towards a paraprofessional, or even this data and local bars for which members have to pay? How would a paraprofessional part in this proposed plan look like for state and local bars?
So I'm not sure I'm totally on understanding the question.
And where is that question? Because I'm not seeing it.
It is in the Q&A. I'll drop it here in the chat as well for the panelists to see. And while the speakers look at the question, I was wondering if anybody from the audience wants to share. I know Anne mentioned client support services. That was very interesting. So if any organization is using these type of programs or models, feel free to share here in the chat so we can discuss later if time permits.
So I think I tell me if I'm not answering the question. But I think you're asking about sort of how paraprofessionals, sort of what sort of formal professional entity they would exist within. And that has depended entirely on the different program. For example, under the Alaska CJW model, they are part of the legal profession in that they're supervised by the attorneys. I think in Washington, they're seen as a different type of legal professional. I don't know that they are part of the Bar Association. I think that they're separate. I'm not sure. But that's actually something that's come up in terms of what should it look like. I think one of the things we've heard actually in particular from our client section is how important it would be for paraprofessionals, practitioners to be connected to professional supports and mentorship, and how important that would be for building trust in their competence. And certainly I think we agree with that. I think those resources and professional supports are really important and would like to see that built in. I'm personally not as familiar with exactly how that looks, and I'm not sure that it really does look like anything yet in a lot of places.
If there's more on that, please continue posting. And while folks are thinking or adding to the chat or to the Q&A, I'll just sort of highlight a little bit of what I have up on the screen now, which is sort of a framework, I suppose, if your programs are grappling with these questions, if you're trying to think through ideas, options, innovations related to expanded legal practitioner models, that the questions in the blue box offer some guidance in sort of how to approach those questions. So being really specific about what problem are you trying to solve? Why are you thinking about this, right? What is it? What's the issue that is happening, that is being experienced by the program, by staff, by clients, that you're wondering, like, might there be a solution here in some way related to a new model? And then very importantly, who are your stakeholders? Who do you need to have at the table as you grapple with this question and this problem, to really be sure that you're getting perspective and input from everybody who's going to be impacted by a new service delivery option, including client communities. As David said, for as much as the jury is still out in many ways, and for as much as we're really trying to be very thoughtful and careful about getting ahead of ourselves on this topic, it is entirely clear that where jurisdictions have neglected to invite client communities and legal aid staff to the table, that there are huge gaps in the models. And so just reiterating the point of being sure you have representation from all sides if you are considering these options. Oops, sorry. What do you know already, I think is a important question not to skip over. So are there data out there that you could look to? Maybe they don't answer the whole question, but maybe they help inform your understanding of the problem or of the current reality. What can you use that exists now to understand better the issue or dilemma problem you're trying to address? And then, of course, the obvious question, is this a situation that engaging legal practitioners in could help improve the circumstances? Is there a piece of it that maybe legal practitioners could help address, even if it's bigger than just, something that having this model would solve altogether? Can you break it into a more discrete set of strategies, and maybe there's a piece that could be improved upon with the addition of legal practitioners? And finally, I really, again, to emphasize David's point about trying to collect good data on these models, planning at the outset for how you're going to evaluate and iterate the program as you learn what's working and what isn't working sounds obvious, but is really easy to skip over. And we often get caught up in doing our work in ways that's super important, and we want to deliver services to clients and don't always take the time to plan and to dedicate resources to that evaluation and iteration process, and want to just emphasize how valuable that is, both to the program that's doing it, but then also to this broader conversation about how we continue to try to problem solve around access to justice writ large. And some of the scenarios I listed here are just very generic examples of things I think many legal aid programs grapple with that could be opportunities for conversation in this area, among, I'm sure, lots of others as well. So I'm gonna go back to our question list because I think I saw some additional notes. Maybe these are just logistical updates from Jorge, not more questions. Okay.
So there was one more question
Go ahead.
in the Q&A, and it's about the paraprofessionals topic. Will the paraprofessionals ultimately still be, to a certain extent, under the supervision of a licensed attorney? That depends entirely on the program. And again, we don't have a position. I think I tried to touch on, but felt like I was running up against time, a little bit of how we're thinking about that. Certainly, I think there's a greater inherent level of comfort with that respect. But it would not have to be, no.
We are at 1 minute. If there's a burning final question, please feel free to share. We will get these slides to Jorge, who I know said he will get them out to you all. I just dropped my email in the chat, so folks are definitely welcome to follow up with me directly if there's anything you want to talk further about or that you think NLADA can be helpful with.
I did drop the CLE code in the chat for anybody that needed to leave right at 1, but if you're available, Ann and David, we can continue on if anybody has any questions or discussion. I did want to admit I am guilty of using non-attorney, so I'll do my best of using other terms. I think my favorite is advocate. That's the one that I use quite often, but I did like some of the terms and the models that you guys presented, and I had a question, and hopefully you could chime on. It just happens that this webinar was originally scheduled for September. Guess what happened? A hurricane happened. And these are the type of things that we do see that trigger these type of models. And I was wondering if you could maybe share any experiences or ideas related to, I really like the idea of the regulatory sandbox as a way to maybe waive some of these requirements during, whether it's a disaster or a pandemic. So I was wondering if you could share your experience or any ideas on how to use these models to assist survivors in these moments.
I do not have an immediate example I can point you to of how that may be, happening in that context, although I think it's a really interesting question. Frankly, what it tempts me to do is kind of run through those questions I just framed, right? So if the problem is, disaster strikes, we have overwhelming need in a very acute, amount of time. There would be the probably similar group of stakeholders that you'd want to invite to the table to think through how does that unique circumstances, like what is the problem there? Is it the overwhelming need with the relatively few providers? And so, that would suggest maybe expanding the number of people who can provide service under those limited, circumstances could be a solution. But what are the then more specific aspects of that, right? What are the sort of discrete needs I would think you'd have to talk through to really understand where you would want to deploy practitioners, right? What are the legal problems that sort of immediately come to the surface that are creating that sort of overwhelming volume for the legal aid network writ large in that disaster crisis? And thinking through that list would be super important, and getting input on what are those top 3 or top 5 issue areas. And then how, and this is where I would really turn it back to all of you, how are services best delivered in the moments after a disaster like that? How do you literally reach people with the kind of help that they're looking for? And are there ways that practitioners could be really valuable from that sense if they're already deployed in neighborhoods, in communities, in shelters, for example, right? So I think that's a really interesting question. Okay.
Don't see any additional questions or comments in the chat. I know we're over a few minutes, so unless I see any additional comments or questions, I wanted to thank you both, Anne and David, for this amazing presentation. I thank everybody that attended and registered for today's webinar. We hope you have found the session valuable and that it provided useful takeaways. I know it did. I definitely have a lot of takeaways from this and a lot of examples and a new wish list of items that I want to explore. Before we conclude, I just wanted to remind everybody that we will be sending out an email with a copy of the link to this recording and the copy to the materials. It will have my email on it. If you have any follow-up questions, feel free to send those our way and I'll share them with the speakers. And yeah, thank you all again. We look forward to seeing you at our future events, and have a great afternoon and a great weekend. Thank you again.
Thanks for hosting us. Take care, everyone.